Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review, and yes, indeed, my name is Jim Santelle. I am your host for this special edition of our broadcast, coming to you beginning at 2 o'clock here on Sunday, June 28th. At the outset, I would like to acknowledge and thank the leadership and the management of Civic Media, including my wonderful producer, Max, for their special contributions, their special support to making this special broadcast possible. We have decided, because of the seriousness and the importance of all of these major Supreme Court decisions issued by our High Court in just recent days and weeks, and yes, indeed, in the months even before our current broadcast, to do this special review. Why? Because once again, pursuant to our commission here on Amicus, a law review, to be a friend of the community, to provide information, insight, education, assisting you to make your own judgments and determinations and assessments of your government in action, including in this broadcast, special emphasis upon the judiciary. The third branch of government, Article 3 under the Constitution, plainly, very important in terms of our lives and livelihoods here in 2025 and beyond. And so today, I thank you very much. I'm honored, I'm pleased that you have decided to spend some of your Sunday afternoon in consumption of this additional review and analysis of Supreme Court cases. Those of you who were part of our listening audience yesterday know that we spent most of our time talking about this major decision in Trump versus Casa. That is this major decision authored by Associate Justice Amy Coney Barrett, finding that the notion of national or universal injunctions can no longer be supported, that the Judiciary Act of 1789 and every moment since then does not indeed support, does not indeed permit local, federal, district court judges to impose nationwide injunctions. They can still enter injunctive relief. They can still give remedies to particular plaintiffs who are in front of them. They can even entertain class actions, but in fact, they cannot anymore, by virtue of this decision just on Friday of this past week, enter universal injunctions. All sorts of applications and implications from that decision. I encourage you, to the extent that you are specifically interested in knowing more about the content, both of the majority opinion authored by Amy Coney Barrett and also the dissents authored by Sonia Sotomayor and Ketanji Brown Jackson, to pull up our discussion from just yesterday about that all-important case. It may well be, as history may well tell us, the most important case of this term. Also, as I argued yesterday, a major bookend to the other major opinion issued by our Supreme Court on July 1 of 2024, giving the president a huge amount of aggressive authority to do things not specifically contemplated by the Constitution. Now, as at least the dissenters have indicated, now not providing a federal district court judge or judges around the country the capacity to stop those directives, those executive orders with that newfound power on a universal or national stage. Lots of debate coming out of that particular opinion, and lots of consequences for the ways in which it changes the ways in which we do law in America. We also talked yesterday about two other cases, one of them involving the Affordable Care Act, which was again implicitly, if not explicitly, reaffirmed by the Supreme Court. We know about the previous challenges to the Affordable Care Act over time. Just this past week, the Supreme Court upheld a provision of the ACA that requires insurance companies to offer some kinds of preventive care for free, supporting the notion that's a task force designed to determine which kinds of preventive preventive care would fall under the law and which kinds would not, that is legitimate, and therefore the Affordable Care Act, again, given not new life, but continued life under its structure as established at the time that the Congress passed that legislation. And then we also noted at the end of our time together yesterday that the Supreme Court, disappointing an awful lot of people who thought that there would be a major voting rights decision in the Supreme Court docket. There was such a case, but they decided, as many of the journalists have indicated, to punt on this case. They decided to send off into the next term, that is the term of the court beginning in October of this year, this fall, a decision about whether or not Louisiana's congressional voting map, as designed once and then twice by the legislature, can in fact stand and withstand constitutional muster under the Voting Rights Act. A question about the extent to which race can be used in designing a particular congressional district there in Louisiana, a district that does look, the mandering part of this, the salamandering part of gerrymander, it appears that that particular district does partake of that. But the question more centrally and more legally is whether or not decisions made by the legislature to draw two districts, a second district with majority black voters, can in fact stand if that decision is premised upon racial considerations, noting once again that there is about 1/3 of the state's population there in Louisiana is black. That question, the decision on that case, will now have to wait until the next term of the Supreme Court. And in the meantime, the two particular majority black districts in Louisiana stay in place until the Supreme Court once again can address that particular issue. In this special edition, this Sunday edition of Amicus Law Review, we're going to talk about three other cases and spend a good deal of time talking about a free speech case coming out of Texas, about whether or not there can be internet access for adult sites, specifically by youths. That is an issue related to free speech issues under the First Amendment. We'll talk about the court's resolution of that. We'll talk equally controversially about a decision coming out of Maryland about whether or not parents have the right to restrict the access of their young students, their grade school students, prohibiting them from seeing LGBT-related storybooks in schools. Can they opt out for that? The Supreme Court issued a decision on that important case, not only for academics, but also a religion case, since the petition is premised in large part upon religious interests and persuasions coming out of Maryland. And then we're also going to talk about a case involving broadband internet access to poor areas of our nation, rural communities. It's a fairly wonky decision under the FCC. FCC versus Consumers Research is the name of the case. We'll talk a little bit about the legal implications of that. And yes, indeed, a 6-3 decision there that affirms the capacity of the FCC to act and to go ahead in a way that effectively does give life and livelihood to the FCC Commission to ensure that communications, and in this particular case, 2025 and beyond, broadband access, internet access, is afforded to rural communities and poorer communities throughout our nation. Before we begin all that, and yes, as I've often said recently, all of this is a lot. We know that the Supreme Court on a regular basis agrees to hear cases and then agrees not to hear other cases. Those decisions typically made by 4 members of the Supreme Court. That is also a part of the deliberative practice. As you know well, there are quite literally thousands of people every year, thousands of entities every term that seek review by the United States Supreme Court. These cases come from the district courts, from the appellate courts, and yes, indeed, under our Constitution, you can also appeal a case from the highest court of a particular state. We have seen that not only in this term of this Supreme Court, but in previous terms as well. All of those courts, those lower courts, generate a lot of work and a lot of decisions. And it's not unusual for both government officials, attorneys general, private litigants, sometimes the Department of Justice, to seek review of those lower court opinions by the Supreme Court. The Supreme Court in recent years, including this term, has limited its review and has done what's called grant certiorari, granting the writ of certiorari. That's the legal process by which they basically say, yes, send up that lower court docket, give me that file, give us a chance to review what you have done. Granting the writ says we will review the lower case decision. Denying the writ says that we will not grant review. And of course, in the great majority, the overwhelming number of cases, the Supreme Court denies review and ends up with somewhere between 60 and 70 cases on a regular basis. No exception this term. They issued about 66 decisions in the end, most of those, not all of them, following oral argument. And we know that along the way, even in recent times, as we have reported here on Amicus, a law review, the Supreme Court has already begun to populate the cases that it will hear in the 2025-2026 term. And that will begin, of course, on the first Monday in October. It has already decided not to hear some cases and to take other cases and put those on its docket. The Louisiana case, for example, is one, again, surprising all of us, not deciding in this term, bumping that, punting that into the next term of the Supreme Court. But along the way, the Supreme Court also making decisions about those cases that it will and will not decide. And so just this past week, the United States Supreme Court issued one ruling in one direction and another ruling in another. The Supreme Court turned away Virginia's appeal just this past week that sought to quash, to stop a challenge to the state's lifetime felon voting ban. Lots of double, triple negatives there to unpack. Two disenfranchised voters claim that the ban violates the Virginia Readmission Act. A little bit of history here. That act is a federal law that set conditions way back when for Virginia to regain congressional representation following the Civil War. Supreme Court saying we're not going to take that up. Lower courts allowed the suit to move forward, saying courts can enforce the Readmission Act and the state doesn't have the immunity that would otherwise attach under the 11th Amendment to the Constitution. But Virginia's Republican-controlled Attorney General's office argued to the justices that they would open the floodgates and make a radical change in the law. Fourth Circuit ruling that the Readmission Act are judicially enforceable invites courts to wade into the political decisions that restored the rebel states to federal representation more than 150 years ago. That's what the Attorney General said, calling into question Congress's continuing determination that the states have Republican governments and are entitled to representation. That was the petition to the Supreme Court. And in the end, in a brief order, the Supreme Court had declined to take up the case. A federal district judge is set to hold a bench trial in October on this case. The United States Supreme Court saying, no, we're not going to take that up. Instead, we'll let that case go ahead. It may see the light of day once again, but not probably in this coming term. When we come back, I'll tell you about another case where the Supreme Court said yes, and then we'll move on to those other major cases that were the subject of decisions by our United States Supreme Court just in recent times. Stay with us for all of that and more. My name is Jim Santelle, and this is a special edition of Amicus, a law review, coming to you on Sunday afternoon by virtue of our decision here at Civic Media to spend some time talking with you, hopefully instructing you, giving you some insight into these great numbers of cases decided by our United States Supreme Court. So you've got a sense not only of what they do, but the ways in which those decisions affect our lives on a regular basis. We have spent some time already talking about three of those major cases in our segments that were broadcast just yesterday here on Civic Media. Also reminding us on a regular basis that the Supreme Court will be back in business again next term. That begins on October, the first Monday in October of 2025, continues until this time next year. And once again, next time but this year, a long ways away right now, we will do this once again, reviewing as we often do the content, the substance, the meaning of these decisions as we go ahead. A part of the decisions process, the decisional process by the Supreme Court, is to determine what is going to be on their docket and what is not. Already told you about the decision to turn away this Virginia appeal to this felon voting ban coming out of that state. There's another decision the Supreme Court made also on the same day. They agreed to hear a case of a Rastafarian man who was seeking to sue prison officials for cutting his dreadlocks. An interesting case. Let me tell you about it. Once again, the Supreme Court saying, yes, we will take this on. Supreme Court agreeing to hear the case of this man who's seeking to sue some prison officials in Louisiana who cut off his dreadlocks while he was incarcerated. The case, again, it's a religious case. It's the latest case involving religious rights to catch the court's attention. And as you know well, as we will reaffirm in this edition of Amicus Law Review, the Supreme Court spends a lot of its time on religious cases in recent terms, including this one, apparently now including next term as well. Could have significant implications for allowing prisoners to sue government officials for damages when their religious rights inside an incarcerative setting are burdened under a federal law that was enacted 25 years ago. The petitioner here, his name is Damon Landor, Landor. He's a devout Rastafarian who began serving a 5-month prison sentence in 2020 for drug possession. He has taken a religious vow years earlier not to cut his dreadlocks. His situation, undeniably, took a bad turn for him after arriving at the new prison weeks before his release. He handed officials a copy of an appeals court ruling from 2017 that allowed prisoners to have dreadlocks, to continue their incarceration with their hair in that status. The guards, according to the allegations in the complaint, tossed it in the trash. They then handcuffed him to a chair and forcibly shaved his head. Following his release, Landor's release, he sued those prison officials and guards for damages under this decades-old law that protects the religious interests of inmates. The lower courts dismissed this case, ruling the law doesn't allow individuals to pursue these kinds of damages against prison officials for alleged violations of it, even though, according to one of the judges, he had been the victim of a grave legal wrong. The Fifth Circuit Court of Appeals said in unanimous opinion that indeed the case cannot go forward. The Fifth Circuit sort of divided on whether to hear the case. President Bill Clinton, and this is the predicate for all of this, signed a bipartisan law in 2000, year 2000, that protects the religious interests of state prisoners. Not clear whether that law allows people who were harmed to sue for money damages. The Supreme Court in 2020 ruled that a similar law, a similar piece of legislation with nearly identical language, allows people whose religious rights have been burdened to seek damages against government officials in their individual capacity. But the question here is novel for the Supreme Court because of the particular application of this law of 25 years ago. And so the question before the Supreme Court is whether or not he's got a right to sue, to proceed with this. A judgment has not yet been entered. But the question again is whether or not this particular now released defendant can in fact sue prison officials for cutting his dreadlocks under this major significant religious rights law passed 25 years ago. Let's begin now to talk about some of those decisions, additional decisions that were rendered by the Supreme Court in just recent days. One of them is called Free Speech Coalition versus Paxton. And yes, you recognize that name. He is the Attorney General of the state of Texas. You know that well. And so what is this case all about? Well, the Supreme Court on Friday Here's the headline to all of this. Rejected a challenge to a Texas law. Again, you've got some double negatives saying no to a challenge that sought to limit minors' access to pornography on the internet. Supreme Court ruling that it does not violate the First Amendment to our Constitution, the federal Constitution, to require people to verify their age through measures like the submission of a government-issued ID before getting internet access. The law plainly was meant to shield minors from sexual materials on the internet by requiring adults to prove that they are at least 18. Again, all of that challenged on First Amendment grounds. Here's the result. Vote was 6-3, right down partisan line once again. And we'll talk about exactly what happened here. The Texas law applies to any commercial website, more than 1/3 of which is sexual material harmful to minors. That's according to the legislation passed by Texas. It does require such sites to use one of several methods, those are described, to verify that users are 18 years or older. It does not allow companies to retain the information that their users submit, which is one of the concerns about the legislation. But the challengers said that adults would be wary of supplying personal information for fear of identity theft, tracking, and extortion. And in many ways, actually, in principal ways, this case became about adult access. More than 20 states have enacted similar laws. When we come back, I'll tell you more about what the Supreme Court did in this case. We'll talk about the majority opinion, the dissenters once again, as Amicus, a law review, continues here in this special edition. This is Amicus, a law review. My name is Jim Santelle. In this special Sunday afternoon edition of our broadcast, continuing to talk with you, engage with you on the sum and substance of these major decisions coming out of the Supreme Court. Yes, they're particular to the parties in front of the courts, including the District Court, the Appeals Court, the Supreme Court, but they have applicability beyond that, and that is certainly true of this case involving the parties' Free Speech Coalition versus Paxton, who's the Attorney General of Texas. What do we know about this case? Well, we know that Texas, like many states, including about 19 others, prohibits distributing sexually explicit content to children. 2023 is the year that the Texas legislature requires certain commercial websites publishing sexually explicit content that is obscene to minors to verify that visitors to the sites are 18 years or older. Knowing violations of that law by these providers subjects them to injunctions and also to civil penalties. The petitioners here, who are the representatives of the pornography industry, sued the Texas Attorney General in this case, saying that what the legislature has done cannot stand under First Amendment standards. They're seeking to stop to enjoin the enforcement of this law as facially unconstitutional under the First Amendment's free speech clause. Specifically, what did they say? They said that adults have a right to access the covered speech and that the statute impermissibly hinders them. Fifth Circuit held that an injunction was not warranted because the petitioners, the challengers, the plaintiffs in this case were unlikely to succeed on these First Amendment claims. The court viewed the legislation as the court said, a regulation of the distribution to minors of materials obscene for minors, and so their focus was on the children. It therefore determined that the law is not subject to any heightened scrutiny under the First Amendment, and that's really how the case plays out. There is no doubt that everyone agrees, again, that states can indeed make limitations on access for non-adults. The question is, does this particular provision overtly and unconstitutionally inhibit adults from getting access to those same sites? And the question presented to the Supreme Court, to the lower court as well, is what level of scrutiny? Should there be a high level of scrutiny because this particular speech should be so heightened, subject to such a heightened standard for protection? Or should there only be an intermediate or lower level scrutiny for analysis of what the legislature has done? In the end, the Supreme Court finds that the legislation coming out of Texas triggers and survives review under only intermediate scrutiny because it only incidentally burdens the protective speech of adults. In other words, the lower standard is applicable here, and because of that, because of the lower standard, the legislation survives. Intermediate scrutiny is the articulated position, and again, important not just for Texas, but for all of these other states that have enacted similar laws. Here's what the majority says, and once again, it's important to recognize that in this particular case, it's Justice Thomas who delivers the opinion of the court. It's his writing, from which I'm going to read in part. And it's Chief Justice Roberts and Associate Justices Alito, Gorsuch, Kavanaugh, and Barrett who join in that. You've got Justice Elena Kagan, who files a dissenting opinion. We'll hear a little bit about that as well. Justices Sotomayor and Jackson joined in that dissent. So once again, a 6-3 opinion upholding the Texas legislation. What exactly does Justice Thomas say in the majority opinion? He says, to determine whether a law that regulates speech violates the First Amendment, the court considers both the nature of the burden imposed by the law and the nature of the speech at issue, kind of balancing those two things. Laws that target protected speech based on the communicative content are presumptively unconstitutional and may be justified only if they satisfy strict scrutiny. In other words, you're going to go after content. We're going to analyze these very, very closely. On the other hand, he says, laws that only incidentally burden protected speech are subject to intermediate scrutiny. That is the level at which Justice Thomas and the others in the majority embrace in this case. It goes on to say laws that restrict only unprotected speech, such as obscenity, receive rational basis review. That's a much lower standard. And as Justice Thomas often says, and very much likes reviews of the past, he says that history, tradition, and precedent establish that sexual content that is obscene to minors but not to adults is protected in part and unprotected in part. States may, in fact, prevent minors from accessing such content, but may not prevent adults from doing the same. And goes on then to say, applying those basic principles, goes on to say again, on behalf of the majority, that this particular legislation, it's called HB 1181, has only an incidental, kind of a collateral impact on protected speech and is therefore only subject to intermediate scrutiny. The First Amendment leaves undisturbed states' traditional power to prevent minors from accessing speech that is obscene from their perspective. That power includes the power to require proof of age, which is what this legislation is all about, before an individual can access that speech. It follows, the justice says on behalf of the majority, that no person, whether an adult or a child, has a First Amendment right to access such speech without first submitting proof of age. That's the core ruling here. That's a very important piece of what the court finds. Goes on to say the power to verify age is part of the power to prevent children from accessing speech that is obscene to them. Where the Constitution reserves a power to the states, that power includes the ordinary and appropriate means of exercising it. Age verification is common when laws draw age-based lines. Obtaining alcohol, for example, a firearm, for example, or a driver's license. He's using other references to suggest that indeed we can draw those age-based distinctions. Obscenity, Justice Thomas says, is no exception. Most states require age verification for in-person purchases of sexual material, and petitioners concede that in-person requirements of this kind are traditional and almost certainly constitutional. And as a practical matter, he goes on to say, age verification is necessary for an effective prohibition on minors accessing age-inappropriate sexual content, especially on the internet. In the end, the legislation is supported and the industry representatives lose. The age verification requirements are upheld based upon the fact that the imposition on adults is only incidental, subject to a lower standard of review, and the legislation passes muster. In the end, the court says the statute advances the state's important interest in shielding children from sexually explicit conduct, is appropriately tailored because it permits users to verify their ages through established methods of providing government-issued identification and sharing transactional data. The judgment of the Court of Appeals, the Fifth Circuit, is affirmed. That's what the majority of the Supreme Court says. Justice Kagan and Justice Sotomayor and Justice Jackson dissent on that, and they make clear that they're not advocating that non-adults, that minors should have access, unfettered access, and any access to this kind of material. She begins by saying, in effect, no one doubts that the distribution of sexually explicit speech to children of the sort involved here can cause great harm. Or to say the same thing in legal terms, this is in her dissent, no one doubts that states have a compelling interest in shielding children from speech of that kind. What is more, children have no constitutional right to view it. The Texas statute before us addresses speech understood in First Amendment law as obscene for minors. She makes all of this clear at the very start of her very extensive 23-page dissent. This is Justice Kagan writing. The state can restrict their access without fear of colliding with the Constitution. That's right up front. A trouble, she says, the reason why she's dissenting, along with Sotomayor and Jackson, is just this. She says the trouble comes in the last two sentences, italics. That is the word "they're" being used, and "for minors." She says speech that is obscene for minors is often not so for adults. For them, she says, the category of obscene and therefore unprotected speech is narrower. So adults have a constitutional right to view the very same speech that a state may prohibit for children. And it is a fact of life and also of law that adults and children do not live in hermetically sealed boxes. In preventing children, she goes on to say, from gaining access to obscene for children's speech, states sometimes take measures impeding adults from viewing it too, even though for adults it is constitutionally protected expression. And then she asks this rhetorical question, most appropriately, what then do we do? What then to do? Well, she says, cases raising that question have reached this court on no fewer than four, count them, four prior occasions, and we have given the same answer, consistent with general free speech principles each and every time. Under these principles, she goes on to say, again, this is the dissent. This is not the law of the case. We talked about that already. The statute still stands. Here is the dissenter saying, under those principles, we apply strict scrutiny, a highly rigorous but not fatal form of constitutional review to laws regulating protected speech on its content. So there you have it. She's basically saying that while the majority is applying an intermediate level of review, here, because of the implications, this should be a strict scrutiny review. And laws like this particular one coming out of Texas fit this description. She says they impede adults from viewing a class of speech protected for them, even though not for children, once again emphasizing this is not about children, and defined by its content. So when we have confronted these laws before, we have always asked the strict scrutiny question, and here it is the law the least restrictive means of achieving a compelling state interest? There is no reason, she says, to change course here. Goes on to say that what if Texas could do better in this instance? What if it could design this law in some different way? What if Texas could achieve its interest without so interfering with the adults' constitutionally protected rights in viewing the speech that this legislation otherwise cover? She says that is the ultimate question on which the court, the majority, and I disagree. And again, the other two also join in this disagreement. The majority says that Texas may enforce its statute regardless because only intermediate, this lower level of scrutiny, applies. And that test does not ask whether a state has adopted the least speech restrictive means available. I disagree, she says, based on conventional First Amendment rules and the way we have consistently applied them in every context. The state should therefore be foreclosed from restricting adults' access to protected speech if that is not, in fact, necessary. When we come back, a little bit more about Kagan's dissent, and then more about other cases decided by the Supreme Court just recently. All of that on Amicus, a law review. This is Amicus, a law review, a special edition coming to you on this Sunday afternoon, talking now about this major case involving the First Amendment and, yes, indeed, sexually explicit materials that are on the internet. The court wrestling with whether or not prohibitions on access by minors also have an untoward and extreme imposition on access for adults. The majority saying, as we have been talking, that under the intermediate scrutiny standard, no problem with this particular legislation, meets the needs of the community, which again, as everybody affirms, ensures that young people, that youth do not have access to any of this material, but does not so infringe the rights of others, adults in particular, to get access to it. That concern was what prompted, again, members of the plaintiff class to seek to have this overturned. The majority justifying this, again, based upon this intermediate scrutiny approach and saying it passes muster for that reason. The dissenting justices, including Justice Kagan, writing this lengthy opinion saying that, well, again, we agree that adults do have some access here. Plainly, youth, the non-adults, do not have any access. The question is, what is the level of scrutiny? And could the legislature have designed a statutory scheme that both accomplishes keeping young people and youth away from this without so infringing the rights of the adult plaintiffs here when it comes to information provided about age confirmation? And in the end, she says applying the strict scrutiny standard, which is what she advocates for, does a couple things. She says it's consistent with all the cases we've decided before. And also, she speculates that even under that standard, Texas probably could have designed something that does, in fact, meet that standard. Near the end of her very extensive dissent, she describes, for example, the things that Texas might have done. And this, again, is very wonky, and it's very much in the weeds, but it's important to understand what she is saying. She said the majority's opinion, plus some of his footnotes, and yes, indeed, this is one of those situations where footnotes are often important because they sometimes reveal things that give you significant context. So the extent to which you look at this dissent, but most importantly, take a look at the majority opinion here as you assess your own views about who is right and who is wrong here. The footnotes also show why all of this matters. This is Justice Kagan writing. She says, concluding that the legislation passes this constitutional muster, that it's okay, the majority states correctly that under intermediate scrutiny, Texas need not show, doesn't have to show, that it has selected the least speech restrictive way of accomplishing its goal. And here's where it gets very linguistically complicated, but it's important. Even, she says, if there were a mechanism that, one, as well or better prevented minors' access to covered materials, and two, imposed a lesser burden on adults' ability to view that expression, Texas could spurn that superior method. In other words, if you can craft something that gets everything done, Texas could still say
the superior method go away. Likewise, the majority, because it is applying a more forgiving standard here, she says it compromises our overall First Amendment jurisprudence. Because you're doing that, you can ignore a host of questions about how far the legislation burdens protected expression. In the fine point of these two footnotes, she says, the majority declares that it has no need to explore, number one, whether the legislation requires covered websites to demand age verification for all their content or only for the subset that is obscene for minors. Two, whether the legislation requires that covered speech be obscene only to a minor, including a toddler, or to all minors, including 17-year-olds. And three, whether the legislation permits websites to use newer biometric methods of age verification, like face scans, that pose fewer privacy concerns than submitting government ID and transactional data. Again, that's a lot. But she's proposing there some other methods by which you can accomplish the same things and be subject, therefore, and probably pass muster under the higher level of scrutiny. She goes on to say, the majority explains that even if Texas answered each of those questions in a maximally burdensome way, requiring government ID to view speech that is protected even for children, because 1/3 of the website's contents are obscene for 2-year-olds, the legislation can go forward. And again, she writes, that is true even if Texas has a less burdensome way of equally or more effectively achieving its objective. She's arguing for the alternatives, and she's arguing that even under a higher standard, those alternatives would meet constitutional muster. Here's how she ends her very lengthy 23-page dissent. She says this: I, if she was in the majority, would demand Texas show more to ensure that it is not undervaluing the interest of free expression. Texas can, of course, take measures to prevent minors from viewing obscene for children's speech, but if a scheme other than this legislation can just as well accomplish that objective and better protect adults' First Amendment freedoms, then Texas should have to adopt it, or at least demonstrate some good reason not to. A state may not care much about safeguarding adults' access to sexually explicit speech. A state may even prefer to curtail those materials for everyone. Many reasonable people, she says, after all, view the speech at issue here as ugly and harmful for any audience. But the First Amendment, she says, protects those sexually explicit materials for every adult. So a state, she says, cannot target that expression, as Texas has here, any more than it is necessary to prevent it from reaching children. Because the majority departs from those views, I dissent, she says. In the end, that's not the law of the case, and the legislation goes forward. When we come back here on Amicus, a Law Review, in our second hour, more of what the Supreme Court has said about life in America. Stay with us for that discussion.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a Law Review. My name is Jim Santelle. This, the second hour of our special edition of Amicus, a Law Review. Commissioning this second hour as we have both the first hour today and our broadcast yesterday morning on Saturday, because we are so focused upon the Supreme Court and the importance of its ruling, commissioning us once again to be informative and educational and affording you the opportunity to hear exactly what it is that our Supreme Court justices are writing about, the disagreements that they have, some of them quite virulent, and affording you, once again, the opportunity to determine on what side of the aisle, on what side of these legal arguments you come down. Don't have to be a lawyer, don't have to be a judge, do not have to be practiced or studying the law. Much of this, and it's the reason why I read so much of the commentary, so much of the express statements by our justices, much of it is common sense. And you may or may not agree with the results of those arguments, but it is accessible in the common domain, the common understanding of language, and the ways in which we understand the worlds in which we live. We begin in this, the second hour of our special Sunday afternoon program, by talking about a matter no less controversial than when we talked about in our first hour. That first hour, of course, focusing upon this case coming out of Texas and whether or not it is an unconstitutional violation of the First Amendment to impose age restrictions and age verification structures upon people, including adults, who are accessing pornographic materials on the internet. The Supreme Court, in the end, applying an intermediate scrutiny approach and saying that, yes, indeed, this passes muster. No inhibition on the First Amendment here. The dissenter is plainly saying, no, this should be a much higher standard, and suggesting that even under strict scrutiny, this higher standard, this legislation could have been recrafted in a way that meets the interests of the state legislature and the legislatures in about 19 other states around the country that have enacted similar legislation, meets the interest in ensuring that children, youth, people under the age of 18 do not have access to any of this. No one disputes that appropriate limitation on young people, but doing it in a way that also provides other remedies in a less restrictive manner for those adults. Again, subjects that reasonable people can disagree on. It is fascinating as a First Amendment matter, and that is the why it is significant the Supreme Court takes it up and further defines, not only for the 20 states that are passing this kind of legislation, but also further defining all of our jurisprudence when it comes to First Amendment analysis, the right to free speech, and related issues. The next topic is no less controversial, as I just indicated. This one is at the intersection of all sorts of hot topic issues these days, and will expose both the merits, demerits of the arguments along the way. This involves a Maryland school district. You know this case well. We've talked about it before here on Amicus. It is at the intersection of LGBT rights and prerogatives and even educational pieces, and the intersection of academics and schoolhouses, and also the intersection with parental review and authorization to not only opt out, but also to dictate to teachers what can and should be instructed to their students. What kinds of instruction, what is the academic curriculum that schools can and should adopt? Can parents overrule that by opting out of particular kinds of things in their public schools that they themselves, for religious reasons, and that's the third intersection here, it's a religious case as well, for religious reasons they find objectionable. A lot going on here. What's this case all about? And why is it important in all of those areas? The Supreme Court, just once again, this past week, finding that public schools, again, not private schools, public schools in Maryland have to allow parents with religious objections, there's your religious piece, that's the First Amendment piece here, to withdraw their children, to remove their children from classes in which storybooks with LGBTQIA themes are discussed. That's the ruling of the majority of the Supreme Court just on this past week. The vote, once again, as before, 6-3, same delineations on the left side, the right side of this petition, and this final disposition. The case, of course, is one of many that the Supreme Court has addressed in the area of religion and also academics and also teacher prerogatives and LGBT rights. All kinds of things intersect. Let's take a brief note of some of those that we have discussed in the past. And we know well the court has ruled in favor, for example, last term of a web designer coming out of Colorado. Remember this case? Said she did not want to create sites for same-sex marriage couples. The Supreme Court said, yes, indeed, we will grant you that right to deny, to refuse to engage in commercial contracts with same-sex couples in putting together websites. They favored a high school football coach. Remember this one? Fairly notorious and famous high school football coach who said he had a constitutional right
to pray with members of his football team at the 50-yard line, public venue, public school, after his team's games. And also the Supreme Court has favored and sided in favor of a Catholic social service agency in Philadelphia. Remember this case? That said it could defy city rules, refuse to follow city rules, and refuse to work with same-sex couples who had applied to take in foster children. So there is a lot of recent history here. There is a lot of religious focus here by the Supreme Court. We will talk at the end of this hour about some of the other cases in this area that the Supreme Court has also decided, including that Oklahoma matter, 4-4 decision finding that indeed there is still such a thing as an establishment clause in United States jurisprudence. But here, once again, intersection of religion and academics and First Amendment rights and parental review as well. All kinds of things going on here. The Supreme Court, 6-3, once again saying that the public schools in Maryland do have to give parents the right to opt out and basically prohibit their children, take their children out of those classes in which storybooks with gay and transgender themes are discussed. They have a religious right to do that, to withdraw their children from those classes on days in which those books are specifically discussed. Now, the case concerns a new curriculum that's adopted in 2022 for pre-kindergarten through fifth grade students in Montgomery Public Schools. That, of course, is in Maryland. That's Maryland's largest school system in the state. The storybooks, and I mention this because of something else that is atypical, not unheard of in the opinions that we're about to discuss, but the storybooks include a book called Pride Puppy. It's an alphabet primer about a family whose puppy gets lost at a pride parade. There's a book called Love Violet about a girl who develops a crush on her female classmate. There's a case called Born Ready about a transgender boy. And Uncle Bobby's Wedding, which looms large in all this, about a same-sex union, a same-sex marriage. Now, where does this all come from? What is the genesis for all of this happening? Well, once again, as I indicated, this case called Mahmoud versus Taylor, that's the name of it, Mahmoud versus Taylor, decided just late this past week. During the course of the 2022-2023 school year, the Montgomery School Board of Education there introduces a variety of LGBTQ inclusive texts into the public school curriculum. That's how this all starts. And those texts including the books I just described, 5 LGBT inclusive storybooks approved for students in kindergarten through 5th grade, stories that include focus on sexuality and gender. Parents in Montgomery County sought to have their children excused from instruction involving those books based upon their religious beliefs. The board initially compromised with the parents by notifying them that when those books would be taught, they would be permitted to have their children excused from the instruction. That compromise was consistent with the board's guidelines for respecting religious diversity, which, again, this mix of all of these things, professed a commitment inside the school district to making reasonable accommodations for the religious beliefs and practices of students. Now, that seems all good and well. What happens is it becomes cumbersome. Less than a year after the board introduced the books, however, it rescinded the parental opt-out policy, the board noting that it could not accommodate the growing number of opt-out requests without causing significant disruption to the classroom environment. In other words, if you look at some of the literature, some of the discussion of this, it becomes, frankly, burdensome for all the requests that are coming in, various kinds of requests, and also the execution of removing students from these classes for portions, perhaps not all of the classes in which these books are discussed. It becomes an administrative challenge. The petitioners then, after this opt-out process is completely rescinded, basically saying no more, we're not going to do the opt-out process as well. There are a group of individual parents and some unincorporated association of other interested parties who also join in on this. The parents come from diverse religious backgrounds and hold what appear to be sincere views on sexuality and gender, which they hope to pass on to their children. That's a part of the record of this matter. Faced with the board's decision to rescind these opt-out processes entirely, when they're faced with the prospect that, no, you can't opt out at all, the plaintiffs here file a lawsuit, U.S. District Court for the District of Maryland, and they assert that the board's no opt-out policy infringed their rights to the free exercise of religion. This, again, is where the parental aspect and the educational aspect and the religious aspect, and yes, indeed, the LGBTQIA aspect all collide, if you will. They relied heavily on a case called Wisconsin versus Yoder. We've talked about that before. In that case, the court recognized that parents, in fact, have a right to direct the religious upbringings of their children, and that right, according to the Supreme Court, can, in fact, be infringed by laws that pose, as the court said, a very real threat of undermining the religious beliefs and practices that parents wish to instill in their children. The petitioners, the plaintiff, parents here, and the others then sought a preliminary, here's the word once again, injunction. They wanted to stop the school district from refusing to permit this opt-out process from going ahead, prohibiting the school board from forcing their children and other students over their objection to read, to listen to, or discuss the storybooks themselves. The district court denied that relief. A divided panel of the Fourth Circuit affirms. And here's the headline. The Supreme Court, again, in this major case involving all of those interrelated issues, the parents challenging the board's introduction of the LGBTQIA inclusive storybooks, along with the decision to opt out, to withhold the opt-out process, those are entitled to a preliminary injunction stopping the school district from prohibiting opt-out and from insisting on the books being presented. As we continue, we'll tell you more about what the majority said. We'll hear, of course, from the dissent, too, as Amicus, a law review, continues.
This is Amicus, a law review, a special edition on this Sunday afternoon because we've got so much to talk about. That includes these major decisions coming out of our United States Supreme Court in recent days. 66 opinions altogether in this docket for this calendar year, this term of the Supreme Court that began way back in the previous calendar year, continues over the summer into late September. We're talking specifically now about this major case, intersection of religion and academics and parental rights and LGBT rights and First Amendment rights, all kinds of things. In this case coming out of Maryland, public schools in the end told by the Supreme Court that they must allow parents, at least at a preliminary nature, a preliminary basis right now, they have to allow parents with religious objections to withdrawing their, having their students exposed to storybooks with LGBTQIA themes. They've got to be permitted to withdraw their students from those classes, and basically affirming the right, the religious right of parents to do that, and telling the school board itself that its opt-out process has either got to be enforced or on a regular basis, some other remedy has got to be identified here. The storybooks, as I read in the previous segment here, interesting because in both the majority and the dissenting opinions here, something happens. And I encourage you once again to take a look at them, even if you don't read through all of the lengthy, and it is lengthy, lots and lots of paper, lots and lots of pages here from both the majority and the dissenting justices. They do something else that from time to time happens. And specifically what they do here is they append to the opinions color pictures from some of these books. Both the majority does it and the dissent do it plainly to make their own points about the nature of these books that are being presented in the Maryland School District to kindergartners and on, to maybe
plainly so that you take a look at those and determine, yes, for yourself, but also to underscore their points that on the one hand, these do in fact infringe the religious liberties of the parents who maintain that these kinds of books are contrary to their religious views. On the dissenting side, that these books are fairly benign and that they basically promote interest in human interaction and good lessons that all schools should adopt and pursue. How do we get there? Well, again, Supreme Court, in an opinion, this one authored by Sam Alito. It is joined in by the Chief Justice, John Roberts, also by Thomas and Gorsuch and Kavanaugh and Barrett. You know who the dissenters are then. That's plainly Sotomayor and Kagan and Jackson. What the Supreme Court says in the majority opinion is that the parental position is just this, that the position of the school board is untenable. And they maintain in the end, that is the Supreme Court, that the parents are indeed likely to succeed on their merits, that the board's policies unconstitutionally burden their religious exercise. That's a significant finding. The court, the majority says, has long recognized the rights of parents to direct the religious upbringing of their children. Those rights, they say, in this case, Mahmoud versus Taylor, the majority opinion, it is the law of this case. Those rights are violated by government policies that substantially interfere with the religious development of children. Goes on to say this, for many people of faith, there are few religious acts more important than the religious education of their children. All sorts of citations here, including to some cases that are seminal in this area. And the practice of educating one's children in one's religious belief, like all religious acts and practices, receives a generous measure of constitutional protection. This, again, is what the majority says in support of the parents. The Constitution protects, for example, a parent's decision to send his or her child to a private religious school instead of a public school. That's this case called Pierce versus Society of Sisters, a major case in the jurisprudence of this area. And the court, as it goes on to say, has recognized limits on the government's ability to interfere with a student's religious upbringing in a public school setting. Citing Barnett, for example, the court held that a policy requiring public school students to salute the flag could not be enforced against Jehovah's Witnesses, who consider the flag a graven image consistent with the First Amendment. Burnett involved an egregious kind of direct coercion. A requirement, this again is in the majority opinion in this case, decided just last week, a requirement that students make an affirmation contrary to their parents' religious beliefs. In Yoder, the court held that the Free Exercise Clause also protects against policies that impose more subtle forms of interference with religious upbringing of children. Then, getting to the substance of this, the majority says the board's introduction of these LGBTQ inclusive storybooks, combined with its decision to withhold notice to parents and to forbid this opt-out process, substantially interferes with the religious development of petitioners, those are the plaintiffs, the parents, the petitioners' children, and imposes the kind of burden on religious exercise that the law and the Constitution makes unacceptable. The books, they say, are unmistakably normative. They are designed, this according to the majority, to present certain values and beliefs as things to be celebrated, and certain contrary values and beliefs as things to be rejected. And here is where we get into the specifics. It's the reason why the majority, and yes, indeed, the dissenters, both attach specific references, visual references. You can read them. You can pull these opinions up and take a look for yourself, not only going to the website and finding the books themselves, but also seeing them right in the orders themselves. When we come back, I'll tell you more about exactly what the majority says about those books, and then, of course, what the dissenters view in the opposite direction. All that as our discussion of religion and education and LGBT issues continues here on our broadcast.
This is Amicus, a law review. My name is Jim Santelle, and we are talking about this major decision issued by the United States Supreme Court, case coming out of Maryland. It is called, once again, Mahmoud versus Taylor. I commend your reading of it. I commend your viewing of the opinion itself, because attached to the very decisions of the Supreme Court justices are excerpts from, and not just textual excerpts, they're actually reproductions of pages of these books. Take a look at them, determine whether or not what Justice Alito wrote about these books is accurate or not. It's significant that he is the author of what I'm about to read out loud. He says this. Take, for example, the message sent by books concerning same-sex marriage. He says many Americans advocate with utmost sincere conviction that by divine precepts, same-sex marriage should not be condoned. Interestingly, he cites Obergefell versus Hodges for that proposition. Well, maybe somewhere in that very important Supreme Court case that affirms the right to same-sex marriage, there's a reference to those who object to it. He goes on to say that group includes each of the parents in this case. The storybooks, however, he says, are designed to present the opposite viewpoint to young, impressionable children who are likely to accept without question any moral messages conveyed by their teachers' instructions. The storybooks, again, Justice Alito says, on behalf of the majority, present same-sex weddings as occasions for great celebration and suggest that the only rubric for determining whether a marriage is acceptable is whether the individuals concerned love each other. That in quotes. The storybooks, he goes on to say, similarly convey a normative message on the subjects of sex and gender. Many Americans, like the parents in this case, he says, believe that biological sex reflects divine creation, that sex and gender are inseparable, and that children should be encouraged to accept their sex and to live accordingly. The storybooks, however, suggest that it is hurtful, perhaps even hateful, to hold the view that gender is inextricably bound with biological sex. There is more of that. The Supreme Court's majority opinion, again authored by Justice Alito, is 41 pages, and that does not include the attachments from some of these books, again, color versions of excerpts from them. Without an injunction, the parents, Justice Alito says, will continue to suffer an unconstitutional burden on their religious exercise, and such a burden unquestionably constitutes irreparable injury, entitling them to the injunctive relief that they are seeking. And for that reason, the parents in this case, they win, at least at this preliminary level. This is an injunctive case. Needless to say, as I've indicated, there are dissenters. And there's a dissenter in particular. We've already heard from her in this broadcast, and yes, indeed, in our Saturday broadcast as well. Her name, of course, is Sonia Sotomayor. Let's take a look at what she says. This is her opinion, also very lengthy, very lengthy. It itself is 39 pages in length, and that also doesn't include the attachments that she provides, also from the books themselves. She begins by saying, public schools, this court has said, are at once the symbol of our democracy and the most pervasive means for promoting our common destiny. They offer to children, she says, of all faiths and backgrounds, an education and an opportunity to practice living in our multicultural society. That experience, she writes in dissent, is critical to our nation's civic vitality. Yet it will become a mere memory if children must be insulated from exposure to ideas and concepts that may conflict with their parents' religious beliefs. Today's ruling, again, this is Sonia Sotomayor, joined in by Justices Kagan and Jackson. Today's ruling, she says, ushers in that new reality. Casting aside longstanding precedent, the court invents a constitutional right to avoid exposure to subtle themes contrary to the religious principles that parents wish to instill in their children, exposing students to the message that LGBTQ people exist
and that their loved ones may celebrate their marriages and life events, the majority says, is enough to trigger the most demanding form of judicial scrutiny. That novel rule, she goes on to say, is squarely foreclosed by our precedent and offers no limiting principles. She gets back to that in just a moment. Given the great diversity of religious beliefs in this country, countless interactions that occur every day in public schools might expose children to messages that conflict with a parent's religious beliefs. If that is sufficient, she and the others say, to trigger strict scrutiny, then little is not. Once again, as we did in the case with respect to pornography coming out of the internet in Texas, this issue of the level of scrutiny to be applied looms large. Worse yet, she goes on to say, the majority closes its eyes to the inevitable chilling effects of this ruling. And here's what she describes about that. Many school districts, and particularly the most resource-strapped, cannot afford to engage in costly litigation over opt-out rights or divert resources to tracking and managing student absences. Schools may instead censor their curriculum, stripping material that risk generating religious objections. In other words, if this is too burdensome, as the Montgomery County schools found, they will simply say, let's get rid of the curriculum itself. The court's ruling, in effect, she says, thus hands a subset of parents the right to veto curricular choices long left to locally elected school boards, and there's the academic aspect of this. Because I cannot countenance the court's contortion of our precedent and the untold harms that will follow, I dissent. There's a whole lot more. The majority, she says, in any event, badly misreads the guidance provided to teachers. Far from directing teachers, she says, to accuse students of being hurtful when they express a degree of religious confusion, the guidance by the school district, she says, is plainly designed to foster mutual civility and respect. That purpose, she says, is clear throughout the materials. For instance, she says, the guidance suggests that in response to a child's statement that being gay, lesbian, queer, etc. is wrong and not allowed in my religion, a teacher could respond, again, according to this guidance, I understand that is what you believe, but not everyone believes that. We don't have to understand or support a person's identity to treat them with respect and kindness. In any community, we'll always find people with beliefs different from our own, and that is okay. We can still show them respect. That is what Sonia Sotomayor is not speaking to in her own dissent. Those are not her words. That's the guidance that is being provided to teachers in Maryland when you come to these circumstances. She goes on to say that recommended response is careful to respect the religious views of students while still encouraging civility and kindness toward others. Those values, moreover, are precisely what the parents in this case say they endorse. We believe, she makes reference to the record, we believe that all humans must be respected regardless of the person's faith, race, ethnic origin, sex, gender identity, sexual orientation, or social status. We believe that all persons should be treated with respect and dignity, regardless of religion, race, sex, ethnicity, gender identity, sexual orientation, or other characteristics. The dissent goes on to say this. To the extent students make comments that may be hurtful to classmates in the room, the guidance recommends teachers discourage that behavior. If a student says, for example, that's so gay, the guidance suggests a teacher may respond, regardless of how it's intended, using gay to describe something negative reflects a long history of prejudice against LGBTQ people. So please don't use it in that way. You may not have meant it to be hurtful, but when you use the word gay in any way outside of its definition, it's disrespectful. Similarly, the instruction goes on to say, if a child says that's weird, he can't be a boy if he was born a girl. The guidance encourages teachers to respond, that comment is hurtful. We shouldn't use negative words to talk about people's identities. The majority's dissent goes on to say, reads those portions of the guidance to direct teachers to accuse students of being hurtful when they express confusion based upon their religious views. The majority only reaches that conclusion, however, this again is Sonia Sotomayor writing for the dissent, by omitting portions of the student commentary to which the students are responding in the guidance. Comments like that, moreover, are sadly not uncommon in the nation's school system, and she provides information about all of that. In the end, she says this: the logic of the court's ruling must also apply to countless other topics. This is the opening of the floodgates issue. Apply to other countless topics, interactions, and activities that may conflict with a parent's religious preferences. And this is the practical application of what Sonia Sotomayor is warning against. She says, what of the parent who wants his child's curriculum stripped of any mention of women working outside the home, seriously averring that such activity conflicts with the family's religious beliefs? It blinks reality to suggest that the simple solution for schools is to create new, discrete units of instruction to cover any set of materials to which a parent objects. The court's analysis, Sonia Sotomayor says, thus reflects all too well the obvious fact that courts are not school boards or legislatures and are ill-equipped to determine the necessity of discrete aspects of a state's program of compulsory education. In the end, she says this: today's ruling threatens the very essence of public education. The court, in effect, constitutionalizes a parental veto power over curricular choices long left to the democratic processes and local administrators. That decision, the majority decision, she says, guts our free exercise precedent and strikes at the core premise of public schools, that children may come together to learn not the teachings of a particular faith, but a range of concepts and views that reflect our entire society. Here we go. Exposure to new ideas has always been a vital part of that project until now. The reverberations of the court's errors will be felt, I fear, for generations. Unable to condone that grave misjudgment, I dissent. That's Sonia Sotomayor. Again, she attaches portions of the books, which you also can digest, even if you don't digest all of the well over 100 pages of material from the majority, which you should read, from the dissent, which you should read, as the Supreme Court, again, this past week, brings together all of these issues in another case involving religious freedom, and says that in the end, the school district there in Maryland has got to provide either the opt-out process or, in the end, as Sonia Sotomayor indicates, has got to remove from its curriculum these things that in the end should be and are a part of an academic setting, an academic pursuit that exposes students of all ages and of all backgrounds to positions and views that encourage their education and their growth. Even as we have said in other cases, and as we have talked in this broadcast, situations that expose them to things with which they do not agree. That's what the Supreme Court has done just this past week. When we come back, a couple more cases on the Supreme Court docket, and then review of what has also been a part of the history of this term as Amicus, a law review, continues.
My name is Jim Santelle, and this indeed is Amicus, a law review, a special edition coming to you on Sunday afternoon as a part of our extensive review of some of the major cases that have come out of the Supreme Court in just recent days and weeks. Here's one that has flown somewhat under the radar, also issued on Friday of this last week. It also deserves your attention, even if you choose not to read, again, the very extensive opinion written by the majority and also some dissenters in this case. It's called Federal Communications Commission versus Consumers Research. It has to do with the Communications Act of 1934, and specifically the commission to the Federal Communications Commission to make available to all the people of the United States reliable communication services at reasonable charges. And the objective is known as universal service.
How does this particular case come about? Well, it has to do, once again, with broadband internet service being provided, therefore, to some of our more impoverished communities, our underserved communities out there throughout the United States of America. As is often related to these cases, the issue is not so much whether or not the FCC can do this. This is plainly a good thing to provide information access and internet access to those people in our nation who do not otherwise have it. It's a part of the FCC's commission. This case, like many others, once again turns on something much wonkier, much more specific, much more in the weeds. It has to do with a contribution factor to something called, once again, this universal aspect of the FCC's commission. I will commend your reading of this after you've read everything else. The upshot is that a majority of the Supreme Court upholds this universal service contribution over objections of some entities out there. Says that the scheme, the contribution scheme to the FCC to support this commission does not violate the non-delegation doctrine. That's the other reason why this case is important, because it basically says that, yes, indeed, the Congress can indeed legitimately give to the FCC the authority to make this regulation. The non-delegation doctrine we have talked about before is this notion that Congress should not be giving to agencies, the experts, the people who know what they're doing, the authority to do exactly that, to act on behalf of the people of the American nation. Here, the United States Supreme Court says we're not going to apply the non-delegation doctrine. We are, in fact, going to permit the Congress to vest in the FCC the authority to do these things involving the universal service and the contribution required of participants. For that reason, the project goes ahead, and the FCC can, in fact, pursue this multi-million-dollar, very expensive, but nonetheless important initiative to bring internet service and broadband services to areas of our nation. All of that also coming out of the Supreme Court just late this past week. I mentioned at the start of our broadcast today and also yesterday that while these are the hot topic cases of recent days, we are well mindful that there's 66 cases altogether. And in these final moments of our time together on this special edition, I'm going to recite to you just the other kinds of things that we have talked about on this broadcast, recognizing once again that we've got some split decisions and some unanimous decisions as well. We recall well this case involving transgender care for transgender use, a 6-3 ruling on June 18th, finding that a Tennessee law that prohibits medical providers from prescribing puberty-delaying medication and providing hormone therapy to transgendered minors, ruling that it does not violate the Equal Protection Clause, equal protection principles. Remember this reverse discrimination case called Ames versus Ohio? This was a unanimous court ruling, Supreme Court ruling on June 5th, that members of majority groups do not need to meet a heightened burden to prove discrimination in the employment setting. The case involved, you may recall, a straight woman who said that her employer had discriminated against her in favor of some gay colleagues. Remember this case involving gun makers' liability, the Smith & Wesson case versus the nation of Mexico, a 9-0 ruling basically saying that the Mexican government may not sue U.S. gun makers over claims that they share the blame for violence of drug cartels in Mexico. Recall this 4-4 deadlock involving religious charter schools coming out of Oklahoma. 4-4 ruling on May 22nd, whether Oklahoma may use government money to run the nation's first religious charter school, which would have taught a curriculum infused with Catholic doctrine. An earlier ruling by the Supreme Court had blocked the school from being allowed to participate in the public school structures. And while Amy Coney Barrett recused herself, the 4-4 disposition there meant that lower court ruling stands. That may return, as many of these other things may as well, to the Supreme Court. There was an excessive force case, police force case, 9-0, also on May 15th. Supreme Court ruling that judges must consider all the relevant circumstances in their scrutiny of challenges to police shootings and not just to the moment of threat. that is posed to the police officer. The case concerns a police officer in Texas who shot and killed a motorist. He had pulled over for some unpaid tolls after jumping on the car as he tried to pull away. A major enforcement case for law enforcement and an excessive force case having to do with the way the courts analyze those. There's a case on April 2nd, also 9-0. The FDA versus White Lion Investments finding unanimously that the Food and Drug Administration had acted lawfully in rejecting applications from 2 manufacturers of flavored liquids used in e-cigarettes with names like Suicide Bunny, Mother's Milk, and cookies. The court returned one aspect of that particular case to a lower court for some further consideration. Recall as well the infamous Ghost Guns case. Recall as well at 7-2, ruling on March 26, that indeed Ghost Guns weapons kits that can be easily assembled into firearms, those can in fact be regulated by the ATF. All of that and more coming out of our Supreme Court this past term. Next weekend, we return to more of this analysis here on Amicus, a law review.
This is 92.7 WMDX Columbus, Madison's home for real news and great conversation.